must follow them. And please, you can go to the Supreme Court website, log in into any court, and you can hear them, identify yourself, and you can watch online. Understand, you don't have to go to Delhi. Those times of court visits are gone now. You sit and watch. You can even watch the proceedings in the High Court. You don't have to go to Chandigarh to watch them. Watch them online, hear the judges, hear lawyers, help you bring up your thought process. So with this bird's eye view of what I wanted to share with you, I thought this is enough to ignite your minds. Now, anybody has any question pertaining to the subject, pertaining to the Constitution, pertaining to family laws, please feel free to ask. And you must ask questions. Yes.
Sir, as you have told us a series of judgments, we can see there is a clear intent of the Supreme Court of India to make a law relating to this reallocation of parental removal. Sir, in earlier instances, also in the cases like Visakhapatnam of the state of Rajasthan, the Supreme Court has laid down a series of guidelines which effectively became a law, the POSH Act. So, can Supreme Court do the same in these like child control, since our country is far, as you said, apart from what the world or the international order is present?
Yeah, that's a very good question. See, you got the point very well. What was the law on sexual harassment in workplaces? Nothing. Came Visakhapatnam, 15 years, henceforth it became the law. See inter-country documents, Lakshmikant Pandey 1, 2, 3, 84, 86, 88. And we ultimately landed up with the Juvenile Justice Section 2015 with adoptions. India's Hand Adoption Convention, CARA became the statutory authority. How did it all start? Guidelines. We call them practice directions of law. We call them guidelines. Another example, Neha versus Rajneesh Kaur, authored by Justice RGNUL. I was assisting in that matter. Law of maintenance in matrimonial matters is an unguided ship venturing into stormy seas of international waters. No principle except the word maintenance, there is nothing more than that. How do you divide? How do you contribute? How do you share? In Neha versus Rajneesh Kumar, guidelines have been laid down by Justice RGNUL, a very well written judgment. And she has said these are going to be guidelines under 142. Meaning, these under 142, by virtue of the support of 141, law laid down by the Supreme Court is final, to be followed by all courts till a new law comes. What is happening in inter-country adoptions? I recently did a matter in the Supreme Court, which is still pending, where children to be taken out of India on basis of Hindu adoptions are not to follow the procedure of the adoption convention. But CARA doesn't agree. So the Supreme Court said they have to go, they go. I read in the newspaper today morning that that same very bench of Justice Nagaratnam and Justice Vishwanathan has given 4 children back to adoptive parents because the parents, biological parents don't want them. And under 142. So what happens? The process of evolution of law, the process of filling gaps in law, the process of creating a thought process for statutory law stems from 142. It happened in Nityanand Raghavan, where Justice Lukur laid down guidelines. But subsequently, Justice Deepak Mishra, in the latter judgment, watered them down. So the practice directions have gone bust. So Surya Varana was watered down in Nityananda Raghavan. And there is again different views of interpretation. So the stream of practice directions is not out of town, maybe this is going on. We'll lay down there, these are the principles, these are practice directions, till you make a law. Think about it. But then, in this matter of inter-country parental child rule, there is already Justice Jindal's committee report. There is a bill of 2019. You can see the report online. So it's a mixed bag, everything contributes, adds, and we are a dynamic democratic structure. We are a sovereign, socialist, secular, democratic republic with freedom of speech and expression. You gag anybody, you can go to court. It doesn't happen in every jurisdiction. So let's see. Maybe by the time you pass our law, yes, something will happen. Anybody else next, please? Yes.
In the matter which you referred some time before, that case was filed in Delhi and the Russian woman fled while her passport was submitted in the court. I read the matter and it was found that the Russian woman was last reported seen with the child in the official residence of the Russian. The Supreme Court declared, I quote, declared that the rule of law is much more supreme than the diplomatic immunity, yet the court advises the Russian envoy to accommodate the Delhi police in helping in investigation. I want to ask on what grounds the courts obviously in the interest of justice advise the Russian envoy to assist in the investigation as such, but how does the court and the law navigate such matters of international law, treaties as well as custodial and family laws?
Very good question. I have encountered this situation before. In Amalgoria, in Kaneka, where you can see these judgments online, where children have been removed. And I come to the end in one matter where there is an amicus in Kerala. I'll come to that later. But coming to your specific question first. You see, passport is in court. Parent is a foreign national. As long as the child and the parent is within the jurisdiction of India, the Supreme Court's order will run throughout the territory of India. Article 32 to 26 lay down the boundaries. Now, in Ravi Chandran's case, a similar thing took place when Mr. Yoda was the Chief Justice. A woman fled, she is an Indian, and kept moving within India. He appointed the CBI. They tracked the woman down, and they kept tracking her cell phone, and they kept through the towers. Within India, they were able to track her, and they caught her and brought her to court. Now, what happens when the other parent is a foreign national, and the diplomatic mission is, I can't use any words, is in the process also there. She's seen with a diplomat, I watched the proceedings. She was seen entering the embassy, she was seen leaving it through her back door. It was known that her father was an FSB, Foreign Services Bureau man in Russia. So unless and until her exit was, I will use the word, facilitated, she could not have left. The bench hearing the matter had been monitoring the matter since 2022, and Delhi police was supposed to keep a tab. I think the Delhi police went lax, and the court came on very heavily with the Delhi police for why they lost control. Now, I tell you what happened. The woman is a foreign national. She went to Delhi. She couldn't get help. She found a route to get into Nepal. From what I think, she must have gone to the Russian embassy in Nepal. She must have taken what is known as an emergency travel document. Now, in international matters, if your passport is lost, stolen or not available, you can walk into the embassy of a country and say, this is my passport of my child or mine. It's lost, it's stolen. Please give me a one-time travel document to go back. And this is what the lady did. And she left. And by the time the court realized or the police realized, she had already fled. Now the question is, will the writ of the court run outside the boundaries of India? Answer is no. Next question. Can the diplomatic officials be asked to answer? Can the diplomatic officials be held accountable? Answer is no. There is a Vienna Convention on Consular Relations, by virtue of which all diplomats have diplomatic immunity, which means they are not bound by foreign laws or Indian laws in matters pertaining to such issues. Obviously, if you commit a crime or an offence under IPC, you may be charged. But if you, these kind of things, these kind of matters, the Vienna Convention gives them a free vote. You can't even call a foreign embassy official to court. It's covered by the diplomatic convention. Now, I have been an assisting at the court in Kerala in a judgment of the first bench, where there was an autistic boy living in Dubai with his father, and the mother was in Kerala. She wanted access to the child. There is a National Trust Act under which she could be appointed as a guardian because the child was autistic. So she applied under that act and she got an order being appointed as a guardian. But the order couldn't travel beyond India. And she filed a writ of habeas corpus. And she challenged the order of the board also in another writ. I was appointed to assist the court. And between me and Justice Mushtaq, who is heading the bench in Kerala, we found out a way. We took the order of the court giving access to the mother in the Indian consulate in Dubai. Now that is Indian soil. If you have a consulate or an embassy in a foreign country, that is Indian soil. So it happened. The writ was carried, order was tested by Supreme Court, judgment was upheld. It is a different matter that the order, the mother did not get all what she wanted. But we could put the order. This is the first time an order could actually be taken abroad. What could be done in the Russian case? If you were able to zero down that the child is in Russia, the Indian embassy in Russia can coordinate with the Russian authorities and say, please give her access. But will you be able to bring her back? No. You have to move the Russian court for her to come back. Now, Russia is a signatory to the 1980 Convention. If we were a signatory to the 1980 Convention, we would have had a central authority in India. Russia would have a central authority. The two central authorities could coordinate and contact could be established. So this necessitates the need for a law, a system, an operational, functional method to be put in place. So, diplomatic immunity, passing orders, you can only blame your own people. You can't touch. And the Russian embassy in Delhi may turn around and say, listen, we didn't do anything. She came to us, she said, we can't help you. She fled, she went to Nepal. She somehow managed to get whatever document she got, and she left. Now, will our writ run into Nepal? Will our writ run to Russia? No. Very totally contrary. See, in sum and substance, whoever is the parent has to act very fast. I did in Bombay. When the man tried to flee, he tried to leave in a boat from Daman, probably to Maldives or Sri Lanka or whatever. The police caught him. We got him back. Time is the essence in such cases. Interesting. Yes, next please. No lady students. Anybody in the front row, back row? Enlightenment from the front row. If you have an interesting question, you can put it to me. Anybody else? Only two people are front rows. Anything else connected with this issue? Constitution, family law, anything? You can see me on my website www.anilmalhotra.co.in. Yeah, sure. Lovely.
Mentioned about existence of the Chief Justice.
Slowly. I can't hear you. You don't have a mic. Come forward.
You mentioned about the existence of Chief Justice position in the Family Court of Australia. So can we expect such positions being coming to existence in India also? And what are your suggestions if such courts exist?
You see, you got a good question. I have just come out with my 10th book, Family Guide, Practitioner's Guide to International Family Law and Indian Respect. If you go on my website, I have a YouTube channel. We are Justice Sikri Chair, Mr. R.S. Sima, senior lawyer, 2 more lawyers. Then we did another one last week with Justice Mushtaq in Kerala. Practitioner Geeta from Madras, Murali from Bombay, where we have discussed what do we need to do, and the answer is we need a family law momentum. We need to create a machinery of a family court structure, family court bar, family court judiciary. The numbers have exploded. We are living with a colonial legislation of 1890 in Guardian and WhatsApp. We have unguided family laws of 1955 and 1956. We've done 75 years. Our family law judiciary has not grown because the Act came in 1984. Most of the places don't have family courts. You will be shocked. Chandigarh, which has the highest matrimonial litigation compared to its population, has no family court. The rules have not been notified. Can you imagine the state of affairs? If there is a guardianship petition, it goes to the civil judge senior division. If it is a divorce petition, the district judge sends it to a district judge. Absolute anarchy. And a family court, and if you go to any district court, everybody does everything. Jack of all trades, master of none. This is the place where you can start. Start developing an interest in family law. Request your vice chancellor to get family law practitioners to speak to you. Have an elective or an optional in family law. Develop your interest, grow, and start at the grassroots level, practitioner in family court where you are. Develop a name. Do nothing else. The seeds are here. You have to sow them here. Only bright young minds like you start thinking in this way. You can pick up any specialization. Today, if you are going to enter into the profession, you can't be a general practitioner anymore.